Okay, let's jump right into this explainer by talking about something we all want, a simple shortcut. In almost any complex, high-stakes job, human nature just craves an easy button. We want that single golden rule we can apply to every single difficult situation that says, hey, here is exactly what the right thing to do is. But when it comes to the legal profession, our source material today makes a pretty airtight argument that this shortcut, it's just a myth. We're going to break down exactly why legal ethics simply cannot be boiled down to one overarching, universally applied maxim.
So every lawyer, and honestly every legal theorist, has to kick off their ethical journey by answering this one massive question. What actually matters in the practice of law? And now it sounds like a basic philosophy 101 prompt, but it is incredibly deep. To answer this is to figure out the intrinsic values at stake in the entire profession. Are we doing this for justice? Are we doing it for human dignity? For the legitimacy of the legal system itself? You literally have to define what matters before you can even begin to figure out how to act.
And right on the heels of that comes the essential follow-up. Okay, what should we do about it? Because let's be real, identifying what matters is only half the battle. This second question gets at the constant, everyday struggle of a practicing lawyer. How do you connect these abstract, high-minded values to your daily, in-the-trenches decisions? I mean, how exactly does a belief in human dignity tell you what clause to include in a really hostile contract negotiation? Bridging that messy gap is exactly why theorists desperately try to invent rules.
Which brings us to the core thesis of this explainer. The author is making a very bold claim here. The ultimate attempted shortcut, what we'll call the master maxim, is a fundamentally flawed map. Theorists love trying to hand lawyers a comprehensive, one-size-fits-all instruction manual, something like, always do what promotes justice. But the author's answer to that is a definitive, hard no. Lawyering is just too unbelievably complex. You simply cannot distill its ethics down into one single rule without severely oversimplifying the very real, very messy moral landscape that lawyers have to navigate every single day. To really grasp why a single rule falls apart, we need to quickly define intrinsic value. An intrinsic value is anything valued purely for its own sake, not because it gets you something else. Compare that to instrumental values. The source gives a brilliant example here. Human dignity, that's an intrinsic value. It just inherently matters, full stop. Political institutions, on the other hand, only hold instrumental value. We really only care about them as tools, as instruments, to protect that underlying human dignity. Since theorists usually can't agree on just one golden rule, the text introduces what's known as the standard conception. Some folks rely on this small, really popular group of maxims that historically tries to wrap legal ethics up into a neat little package. This is, for all intents and purposes, the traditional rulebook that pops into most people's heads when they think about the legal profession.
Breaking down the standard conception brilliantly shows us how it operates. There are three main pillars here. First up, partisanship, meaning your absolute sole allegiances to your client's interests. Second, neutrality. You deliberately refrain from judging the moral merits of your client's position. And third, non-accountability. Society essentially gives a lawyer a pass and doesn't hold them morally responsible for whatever goals they pursue for that client. But the author argues this is actually a massive reductionist trap. It shrinks a lawyer's entire ethical universe down to just the client's considerations, basically locking any competing intrinsic values right out of the room.
Okay, let's look at a clash of the reductionists. Some theorists really push back against the standard conception and try to replace it by boiling everything down to just one competing master value. On one side, you've got William Simon, who says, look, lawyers should just take actions that promote justice. On the flip side, you have Bradley Wendell arguing that the fundamental obligation is actually fidelity to the law, specifically to protect political legitimacy. Both of them are trying to offer that ultimate easy button, telling lawyers to filter out everything else and just focus on their one preferred value.
But here is the fatal flaw with reductionism. To make a single master maxim work, you have to forcefully cram all other intrinsic values into just one category. Say you pick political legitimacy as your golden rule. Well, what happens when it violently clashes with human dignity or autonomy? In the real world, you can't just close your eyes and pretend those other values don't exist. It is quite literally an impossible task to squeeze the messy, complicated reality of human conflict into one tiny philosophical box.
It's honestly fascinating to watch this play out in the text itself. We actually see Bradley Wendell grappling with his own maxim of political legitimacy. Because deep down, he knows other intrinsic values exist. He can't even nail his own rule to the wall when faced with competing values. He tries offering different versions of his rule to account for these conflicts, and the result is this amazing bit of theoretical whiplash.
Just notice how he starts his argument.
First, he calls a lawyer's fidelity to the law a very weighty reason that should only be overridden in extraordinary circumstances. Okay, sounds reasonable. It's a strong rule, it's highly important, but he's intentionally leaving the door cracked open. It can technically be overridden by something else.
But then, out of nowhere, he abruptly shifts his language. He starts labeling it an exclusionary reason. Now, in legal philosophy, an exclusionary reason is one that supposedly blocks out all other considerations entirely. It tells you to literally exclude other values from your brain. So wait, the door is suddenly slammed shut.
And yet, while talking about the exact same topic, he turns around and weakens the rule, describing it as a mere prima facie obligation. That basically means it's a presumptive obligation. It looks like a duty at first glance, but it is absolutely open to being outweighed once you look at the specific facts of a case. Boom, the door is wide open again.
The Maxim just completely refuses to hold still. He jumps wildly again, now calling it a near absolute obligation. And look, the author isn't pointing this out to attack Wendell personally. They're highlighting this to show that real-world ethical dilemmas simply will not fit into a single box. When a theorist tries to forge a master rule, they end up constantly adjusting its strength because they know that eventually other intrinsic values are going to crash right into it.
Wendell eventually tries to defend his fluctuating rule by saying, well, it applies most of the time. I'm not designing a system for extreme cases. But the author counters this with a brilliantly vivid concept, moral Antarcticas. If you're a public defender or a prosecutor, extreme ethical conflicts aren't some rare once-in-a-career anomaly. They are the daily, freezing reality of your job. A moral compass that only works in sunny weather is completely useless when you're caught in a blizzard. So what's the actual takeaway here? The only realistic path forward is to abandon the idea of a shortcut entirely. We have to accept that true, rigorous ethical reasoning requires multiplying the things we consider, not reducing them. Instead of trying to put blinders on and ignore competing values, an ethical lawyer has to bring every single one of them to the table. Is it harder? Yes, absolutely. But it's really the only honest way to practice.
Let's look at an alternative approach that totally ditches the magic shortcut. David Luban's four-step analysis is a perfect visualization of why a complex, multi-layered process is just vastly superior to a master maxim. If a lawyer is asked to do something morally sketchy, they don't just check a single rule. First, they have to justify the institution itself, our adversary system. Second, they have to justify their specific role within that system. Third, they justify the obligations that flow from that role. And only then, at step 4, do they justify the specific individual act. It literally multiplies the ethical workload by 4.
This whole deconstruction of the easy way out brings us right back to a brilliant quote featured at the very beginning of the source text. It's from philosopher Rosalind Hursthouse, and it perfectly encapsulates why abandoning these shortcuts matters so much for anyone facing tough professional choices, lawyer or not. She writes, "A normative ethics should not aim to provide a decision procedure which any reasonably clever adolescent could apply." I mean, what a mic drop. This quote entirely validates the reality of the profession. Navigating professional ethics is not about plugging data into a neat little formula to get a guaranteed correct answer. It requires real adult maturity, profound judgment, and perhaps most importantly, the capacity to tolerate tension. Sometimes you just have to hold two competing intrinsic values in your head and make a really hard choice, knowing full well that both of them are deeply important. So, I'm going to leave you with this final, provocative thought. If comprehensive maxims and golden rules are just a myth, maybe it's time we stop searching for a rulebook altogether. Instead, maybe we should start deeply examining the actual virtues required to practice law effectively. Think about it. What kind of character, what kind of resilience, and what kind of judgment do you actually need to build to survive in the moral Antarctica? Thanks so much for exploring this explainer with me.